So welcome, everyone, and thank you very much for joining us today. I would like to officially welcome you to this webinar called Rethinking Data Protection in Academia, a path toward privacy and accountability in gender-based violence cases. My name is Diana Puerto-Michaud, and I am the Legal Circle Facilitator within GenderSafe, and I will be moderating today's session. Before we begin, just a few practical points. This session will last approximately 1 hour and a half, including time for questions at the end. You are very welcome to interact with us using the chat throughout the webinar, and we encourage you to post your questions there. We will address as many as possible during the Q&A session at the end. Please note that this webinar is being recorded. However, no participant interventions, comments, or questions will be captured in the recording. Only the speaker's presentations will be included. Finally, just a brief word on the context. This webinar is organized within the framework of the GenderSafe project, which aims to support research in higher education institutions in establishing safe, inclusive, and respectful environments by setting up comprehensive policies to effectively counteract gender-based violence in the European research area. GenderSafe provides coordinated action and support to higher education institutions to put policies in place, ensure their uptake and implementation, and increase awareness. So on behalf of all the GenderSafe partners here today, we are very pleased to have you with us as part of this important conversation. To start, I would like to introduce you to our guest speaker, Dr. Tommaso Soave. Tommaso Soave works as an associate professor of law at Central European University, where he researches law and technology, international economic law, and legal theory. For the last 6 years, he has taught data protection law to students from a wide variety of jurisdictions. Before joining CEU, Tommaso worked as a dispute settlement lawyer at the World Trade Organization and as an associate attorney at Sidley Austin LLP. He also regularly serves as a consultant for the intergovernmental and non-governmental organizations on matters of trade and investment law. And for the past 5 years, he has been a member of the Ombudsperson's network at CEU. So Tommaso, thank you for being here today. The floor is yours.
Thank you so much, Diana, for the kind introduction. Good morning, good afternoon, good evening, everyone, depending on where you are. I would share the PowerPoint. I hope it's well visible to all. Is it visible?
Yes, we can see it.
Fantastic. Diana, again, thank you and your GenderSafe colleagues for the invitation, and especially for the very important work that you are doing. Now more than ever, our universities and academia in general need robust reporting, monitoring, and disciplinary systems to address and eradicate gender-based violence. Let me call them eradication systems for short, because that's quite a long definition. As I look around the virtual room, and we've discussed in the past, there are so many important systems already in place or ready to take off. These systems take so many different forms, right? So if we look at my university, CEU, you have various mechanisms. I'm happy, of course, to discuss other types of mechanisms. We have interfaces for reporting gender-based violence, entering information, sometimes on an anonymous basis. We have systems for monitoring that information at the aggregate or statistical level. We have ombuds networks, offices, mediators who can receive complaints, they can gather information, sometimes they can even mediate lesser or less severe cases. We have investigative and disciplinary committees tasked with impartial fact-finding and sometimes with imposing or recommending sanctions against perpetrators. We have human resources officers who can monitor employees and sometimes take action based on contract or labor. And then we have, and I know that this is a bit more forward-looking, experiments at building information sharing systems across universities. The idea of sharing information about perpetrators of gender-based violence and follow the perpetrators as they move from one university to another. Now, when we design and roll out these various systems, we are faced, and I know you're very well aware of it, with a lot of regulatory requirements, overlapping and interlocking regimes. We have our internal disciplinary codes. We have contract and labor law. We have administrative procedure, sometimes even criminal procedure. So there's a lot of constraints on action. But what I'm here for today is discuss only one of those regimes, that is European personal data protection rules. So many rules and disciplines, especially under the GDPR, the General Data Protection Regulation, are extremely relevant, extremely important for eradication systems. For the survivors of violence, data protection is important because it ensures a safe reporting space where one can speak up without fear of retribution. But also for alleged perpetrators, data protection is important because it ensures a modicum of due process. It makes sure that no reputational harm comes from mere rumors or conjecture and so forth. Now, the problem is that being relatively recent, the GDPR has a bit of a cult following sometimes. There are so many GDPR zealots, lawyers, DPOs, who in the best case scenario are very, very conservative when it comes to the idea of sharing gender-based violence-related information. And in the worst case scenario, even actively use the GDPR as an excuse, as an artificial roadblock for the implementation of eradication system. So my basic goal for the next 15 minutes or so is to think about how to design a gender-based violence eradication system that incorporates data protection disciplines, but without hiding behind data protection as an excuse for inaction. And I think that the best way to go about it is to look at various rules and principles under the GDPR, not in isolation, but together. Think about these as a set of toggles and dials that we can adjust to get the right tuning as we build and implement our eradication systems. So in particular, I want to focus on these toggles and dials, but of course, I am happy to expand or elaborate on other aspects if the discussion so requires. Is that okay? Wonderful. So I thought I would start from the basics. Sorry for putting a bit of legalese on screen, but at least we have a textual basis to work with. And start with the question of the very definition and nature of personal data. Article 4 of the GDPR says that personal data is any information that relates to an identified or identifiable natural person. Now, there's no question that allegations of misconduct are personal information in the sense that they're very sensitive and that they relate to people, at least two people, the victim and the perpetrator. But the question can arise sometimes as to whether these people are identified or identifiable. To make things clearer, I think that this is one of the toggles that we can start playing with. A number of universities, a number of institutions are resorting to anonymization techniques in order to avoid any problems with the GDPR when it comes to building eradication systems. How does that work? Suppose that you have an allegation of misconduct directed at a university community member, an allegation of misconduct directed at me as a professor. One thing that my university can do if they want to avoid GDPR problems is to separate the allegation, the facts, from my name or any other indirect identifier, say the Italian professor, the legal department, blah, 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 blah. So once these two are separated, the university can then put the identifiers, the names, etc., in a vault, and give away the key to a trusted member of the institution that is under orders not to give the key back, even on request, right? So that, in a nutshell, is anonymization techniques. They're increasingly common. And once you have anonymized, truly anonymized information, then you don't have personal data to begin with. And you have no data protection obligations to begin with. Now, this is already useful for some of the eradication systems that we're talking about, especially those that use anonymized information for statistical or aggregate monitoring. Your university want to know how prevalent gender-based violence is in your institution. You can use anonymized data to get an aggregate picture, and based on that picture, you can already roll out awareness campaigns. You can calibrate your institutional communications. You can fight for culture change and so forth. Now, of course, the problem is that if you want them to act on individual cases of misconduct, well, then this does not really work anymore, does it? In order to proceed with investigating and sanctioning instances of misconduct, you need to put the conduct and the identity back together in order to move forward. And so at that point, anonymization really doesn't help you anymore. At that point, you're under the purview of the GDPR, okay? But even if you're under the purview of the GDPR, there are so many things, so many grounds that support processing of personal data for violence eradication purposes. And I think the most important rules that I want to talk about here are those contained in Article 4 of the GDPR, the famous or infamous grounds for lawful processing. So under Article 4, processing is lawful if at least one of the following applies. Let me give you only a few of these scenarios. First, data subjects have given consent to processing for one or more specific purposes. 2, the university, the controller, is processing because that's necessary to comply with the legal obligation to which the university is subject. 3, the university is processing those personal data because it's acting in the public interest or in the exercise of an official task or authority. 4, the university processes personal data in pursuit of its legitimate interests. Now, before I get into the weeds of these various grounds, here's my advice. Remember, these scenarios are not cumulative, they are alternative. So that means that it's sufficient for one of these scenarios to be there, one of these grounds to be present, and your eradication systems will be considered GDPR compliant, okay? So my advice as a lawyer is go for a belt and suspenders approach. Always try to have in place at least 2 of these grounds. Have them, even if that's a bit redundant, that ensures that if one of these grounds ceases to exist for any reason, you still have other grounds for lawful processing in place. Okay? And so let me look through them real quick to give you an idea of how these could look like. So the first ground for lawful processing of personal data is consent. You can, in your institutions, secure the consent of your community members, students, faculty, staff, to have their personal data processed for the purposes of reporting, investigating gender-based violence. So this is the first step that you should probably all undertake. And how's that done in practice? Well, through consent forms. Consent must be unequivocal. It can be given in writing. So one way to do that, for example, is to include these consent forms in all new university contracts. You hire a new professor, put the consent form, attach the consent form to the recruitment contract. For those universities where students also have contracts, kind of study agreements of the sort, there too, that's a good place to include consent forms. For pre-existing staff that might have signed their employment contracts 15 years ago, well, you can proceed separately. You can include a consent form in an email and request them to reply and indicate their consent and so forth. So this is a basic instrument that you can roll out relatively easily with a couple of caveats, of course. So consent must be free and informed. So that means that you need to be quite detailed and transparent in what these community members are consenting to. You need to be clear about the purpose of the processing, the type of information that can be processed, the procedure for handling processing those data, who has access to them, for how long the data are stored, and so forth. You also have to inform those community members that they have rights over their personal data. Let me tread lightly on those because I'm sure they will come up in discussion in a moment. But so rule of thumb here is clarity about what people are consenting to. And that already gets you off the hook. Problem is that consent can be withdrawn at any time by data subjects. So if they withdraw consent, then you will need some other ground to keep processing personal data for violence eradication purposes. So non-consensual grounds for processing. And so the most important that I could think of, so two very useful ones, for example, are these legal obligation and official authority grounds. Remember, a university can process personal data if it's doing that in pursuit or in compliance with a legal obligation to which the university is subject, or in the exercise or of official authority. Now, plenty of our universities meet those conditions. If you have a public university, very often the public university will be subject to public law rules by definition. If you're a private university, well, then the local law could impose some obligations on you. For example, here at CU, we are under an Austrian law imposing a legal duty of care towards our staff. And so if you're acting and you're processing personal data in pursuit of these, so according to these grounds, well, your processing is lawful. With one very important caveat, that is this. The key principle when it comes to these forms of processing is the principle of necessity and proportionality. In a nutshell, that means that the more intrusive your data processing is, the more you dig into personal data, the more calibrated and well safeguarded the procedure must be, with adequate data security, limitation in what you can and cannot do with these data, and so forth. I guess that the fundamental question, a good heuristic that you can ask, like a question that you can ask yourself as you're designing these systems is, I need to pursue this goal, eradicating gender-based violence. Is what I'm doing, the system that I'm designing, the least data intrusive option that I have to achieve that goal? Are there reasonably available alternatives that would be equally effective in investigating gender-based violence while also being less data intrusive? So there's plenty of case law from the Court of Justice of the European Union about what necessity and proportionality means. I'm happy to develop on that later in discussion. Okay? If even these grounds are not sufficient, then there is one catch-all ground that is probably the most flexible, that is legitimate interest. A university can process personal data in pursuit of its legitimate interests. Why is this very flexible? Because the definition of legitimate interest, what counts as a legitimate interest, is incredibly broad. A university can have a vast array of legitimate interests, going from the most existential, ensuring quality and integrity in research and teaching, say, to very mundane legitimate interest, like, I don't know, marketing its activities in student recruitment campaigns. And so all of these might potentially justify processing personal data, again, with proportionality being the key principle here. The more important the legitimate interest that you're pursuing, the more you're authorized to intrude into the data privacy of your community members. And I would say that eradicating gender-based violence, well, is pretty high up in the ranking of the interests of a university. So when your data protection officer says, well, are we sure that we can do that? Well, you can tell them there is a legitimate interest in ensuring a gender-based violence-free environment. This is important, and therefore that authorizes and justifies a little more intrusion into the data privacy of our community members. Now, of course, there will be plenty of other toggles and dials that I could speak about. Let me just mention a few. The GDPR also has a number of other processing principles that apply across the board. The most important that I haven't covered yet being data minimization and storage limitation. The idea that the amount of personal information that you collect and process should be kept to what is necessary to achieve the goal, both in terms of quantity and in terms of time of storage. Once that information is no longer relevant, that information should be deleted, should not longer be stored. And then there is the principle of integrity and confidentiality. This is quite important. As you design your systems, you need to make sure that you have technical and organizational measures in place to protect collected personal data from unauthorized or unlawful access, processing, against leakage, accidental loss, destruction, or damage. So that is also something, a more technical aspect of things that you have to keep in mind. There are several ways in which you can comply with those principles. Here at CEU, for example, when it comes to data minimization and storage limitation, we have the practice of converting employee records into simplified records after a number of years. That means that after, I think, 5 years, somebody correct me if I'm wrong, the full employee file is stripped down, and what is kept is just the very essential information about employees. So this is one way to comply with these principles. When it comes to integrity and confidentiality, well, what is adequate measures also depend on the capacity, right? So if you are a very well-established institution with a lot of capacity to take technological, technical, and organizational measures, you're probably going to be held at higher scrutiny than if you are, I don't know, a single ombudsperson misplacing their phone on a bus. So there are questions of case-by-case adequacy. I'm looking at the clock and I need to stop, but let me conclude with a few rules of thumb. If you want to be GDPR safe as you roll out your violence eradication systems, first, be clear and transparent with your community members. Let them know through public communication, internal communication, institutional communication about the scope of processing, what that is for, the value of that processing, who has access to those data. The more transparent you are, the more protected you are under data protection law. Second, much of this design and rollout involves technological means for safe data storage, for safe reporting. Here at CU, we have a wonderful Speak app that was developed under the leadership of the Gender Equality Officer. It's wonderful for many purposes, but don't leave this technology unsupervised. So real data protection much as real violence eradication requires human judgment, vigilance, choices, institutional culture. And so try to develop the culture. Don't delegate the job to technology alone. Try to develop a culture where the goals of gender-based violence eradication and compliance with data protection go hand in hand, and integrate them into your workflows as much as possible. And finally, don't be zealots, don't be perfectionists. The GDPR does not prevent the building of effective gender-based violence eradication systems. Mistakes can be made. Try to avoid major blunders, major leakages of information, for example, but don't be afraid to start building. If you want to get everything perfect from the get-go, you will never take these systems off the ground. So leave some time for tinkering, experimentation, and institutional learning. Okay, let me stop here, and I look forward to discussion. Thank you.
Thank you, Tommaso, for your presentation. I'm sure we all have so many questions now that we want to ask you. I think there are a few that come to mind particularly, so I think I will start with the questions. And again, to our participants, feel free to place them in the chat, and then when we start the Q&A, we can address them. So for me, something that's very important in relation to gender-based violence and institutional responses are reporting mechanisms, specifically the anonymous reporting mechanisms, because many members of our community of practice face challenges when implementing these types of systems, particularly when they try to implement a system where the reporting party is allowed to name the alleged perpetrator and provide a detailed description of the incident in a complaint form. So from a GDPR perspective, what do you see as the key challenges in these cases? And perhaps what guidance would you offer to institutions trying to implement this type of reporting mechanism?
Great, thank you. So I do agree that anonymous complaints are a very useful tool. People tend to be afraid of them because of they fear that anonymous reporting will turn into an inquisition where someone is accused without knowing the name of the accuser, and so on and so forth. There are certain issues that can arise when it comes to due process. Probably no one should be sanctioned, dismissed for misconduct without at least getting an opportunity to defend themselves from the accusations. These are all important things also under labor law. But when it comes to the GDPR, there are not so many obstacles to anonymous reporting mechanisms. So first of all, I would ask, what does it mean to have anonymous complaints? You can have two scenarios, right? You can have complaints that are truly anonymous. That is, the identity of the complainant is not known to anybody, not even to the university itself, right? We have a system, for example, here at CEU under the Speak Up, where anonymous complaints are unknown to any person in the university. They are simply recorded in the app for record keeping, but no one can really access them until they reach a certain persistence and severity and consonance, etc., etc. So in those truly anonymous complaints, you have zero GDPR problems because you don't have personal data, at least when it comes to the complainant. Now, the other type, the more frequent type of anonymous complaints is those complaints that are actually only confidential, where the identity of the complainant is known to the university, but is not made known to the respondent, right? So under that scenario, of course, you have issues of data protection to ensure two things. First, that the identity of the complainant is preserved, is kept confidential, if there are concerns concerns about retaliation, for example. And then, of course, you have the respondent's interest in data protection, meaning that anonymous complaints should not then be spread as rumors across the university and so on and so forth. Again, the legal basis for these systems to like lawfully implement those systems are the same that I've outlined in the presentation. First, consent. As part of your consent forms for community members, you can tell them, do you agree to have your personal data processed, if you're respondent, for the purpose of our anonymous reporting system? So community members can say, yes, fine. By working here, I accept that my personal data can be processed when some anonymous allegations of misconduct are directed against me. But even without that, that might be sometimes tricky. People might be scared and so on and so forth. You still have official authority, legal obligation, and legitimate interest grounds for lawful processing. So you could make a decent case to your DPOs that disclosing the identity of a complainant would expose that complainant to retaliation, or would expose that complainant to health and safety risks, or even would undermine the community's trust in the reporting system. European DPAs, data protection authorities, have issued guidelines that basically tell you that whistleblowing systems are fine under the GDPR. What is important to keep in mind is, of course, a question of necessity and proportionality, right? So if you design a procedure, for example, where an anonymous complaint is handled carefully and with only by retaining only those data that are key to the allegation, right? Giving due process rights to the respondent person and the ability to defend themselves, there is no problem with that. If anonymous reporting is extended to anything under the sun, so for example, this professor is a very bad teacher, or he doesn't know data protection law, etc., etc., and if that is not adequately protected, right, and that becomes, for example, public knowledge across the community, well, that might be an abuse of the anonymous disclosure system. So it really depends on how you design the handling procedures and the data collection procedures. But inherently, there's nothing in the GDPR that prevents anonymous complaints of the kind that you're referring to.
Okay, thank you. Thank you for this answer. As I said, it's a lot of comments that we had from our gender safe community of practice in relation to naming specifically the alleged perpetrator, and I'm very glad to hear this. Also, I think in relation to this topic comes to mind the data subject access requests. And I know this because many institutions that are part of this community struggle with how to handle these types of requests in cases of gender-based violence. And what we often hear them say is, okay, if we store this information about a person, then we will have to share it with them if they submit a data subject access request. So I wanted to know exactly how accurate is this assumption? And could an institution limit or perhaps refuse this type of disclosure of data? And if so, what would be the legal grounds? Because I feel it's particularly important in order to protect victim survivors, of course, but also to ensure a fair and safe procedure for everybody that's involved in a complaint. So what is your view on this?
Thank you. Yeah, this is a hot topic, and I've had my share of experience with this type of requests. Indeed. So one of your rights as a data subject, so any person whose data is processed, well, you have the right to request your controller, so your institution here, your university, to disclose whatever personal data they might have processed about you. And we know from the jurisprudence of the Court of Justice, I'm thinking about, for example, the Novak case, that these subject access requests can be quite broad. If I suspect that I'm being watched because somebody might have accused me of gender-based violence, I might ask CEU information about that. And CEU will be, in principle, obliged to provide that information to me. So the nature of the allegations, witness statements, credibility assessments from an investigating body, and internal evaluations, exchange of emails between investigators or the leadership, and so on and so forth. All of this is personal data. It's subject to potentially subject to the access request. I think there was a relatively recent case at Oxford. There was this academic at Oxford who requested disciplinary and investigation data, and UK courts found that indeed Oxford was under an obligation to share these investigation files with the requesting data subject. So in principle, this duty is a duty. That is true. But that's not the end of the story, because as we know from Article 15 of the GDPR, in responding to these requests, the controller, the university, must not adversely affect the rights and freedoms of others, the data protection of others, right? So suppose that I'm requesting CEU to tell me about an investigation open against me in the name of the complainant, right? A complainant that has expressed the desire to stay anonymous, to remain confidential. So at that point, CEU, so my university, must reply to my query, to my request, while preserving the data protection of the complainant. So these can be done in several ways. There's plenty of practice and best practices out there. So in responding to subject access request, the university may refuse to disclose entire documents. They could redact those parts of the documents that contain data about other parties. They might decide to provide only summaries of the documents. They might even refuse to comply with the request if it's impossible, only if it's impossible to comply with the request without revealing confidential information, protected data from others, right? So I guess the structure is, if you can reply to an access request fully, then you're under an obligation to do that. If there are other third-party data at stake, then you must redact, summarize, expunge those data from your reply. And if it's impossible to do that because the object of the reply would necessarily disclose confidential data about others, then only then can you refuse to comply with the subject access request.
Thank you. That was very clear, and it's very nice to have the structure in mind so everybody can take back to their institution. We've already been getting some questions in the chat, but before I go on to read them, I wanted to ask about one more thing, and it has to do with communication. So the information that institutions provide to the parties of a complaint during the handling of this complaint. And my question comes because some European higher education institutions argue that GDPR prevents them from communicating the outcome of a complaint to the reporting party. And also, for example, of communicating precautionary measures that might be imposed throughout their procedure. Now, of course, the argument that we hear is that this is personal data of the respondent, and so we couldn't give this to you. So really what happens is that after filing a complaint, the reporting party never hears about the results of the investigation or if the reported party was sanctioned. And as part of a community, they still have to coexist and work and study in the same place. So I'm wondering what competing rights and legal obligations are involved here, and what recommendations would you offer to institutions that are seeking to navigate this balance responsibly?
Right, I see. So this is a tricky question. Let me give you the scenario. So I complain about misconduct by another community member. An investigation is open, and then a sanction. So they find misconduct and they impose a sanction, but they cannot. So the question is, can they tell me, complainant, about what they've done at the end of the
Exactly,
process?
exactly. At the end of the procedure,
Hmm.
normally, so it's like the results the investigation
Hmm.
gave, or if necessary, if any precautionary measures. So these measures that would come during the investigation just to safeguard the reporting party, which is
Hmm.
the victim survivor of gender-based violence.
Great. So again, going back to the grounds for processing that I touched upon in my presentation. So are these outcomes of investigations personal data? Absolutely. They are sensitive information about a community member. So if that community member, for example, has been fired for misconduct, that's very sensitive information. How do you communicate that lawfully to a complainant? Again, through these various grounds for processing. So first, the the sanctioned community member might have consented in the past to have their personal data processed in the form of communication if they are the subject of a sanction. So you can secure that type of consent. You can add that as a clause to your consent form if you want. But even without that consent, that once again might sometimes be difficult to achieve. You have legal obligation, you have official authority, and you have legitimate interest as grounds. Let me take, for example, legitimate interest. You could make a case as a university that as part of your legitimate interest in eradicating gender-based violence, you're also pursuing a number of other legitimate interests. For example, transparency towards complainants, trust in the system, right? If I'm a complainant and I have an investigation initiated and then that's a message in a bottle and I don't know what happens with that investigation, I will probably lose trust in that system. Sometimes it could be victim protection, right? So is this perpetrator of violence, will I find this perpetrator of violence in the office the next day, right? It could even be procedural, right? Some universities have appellate systems to challenge decisions by investigative bodies. So the dissatisfied party, including the complainant, might want to appeal. In order to appeal, you need to know what happened in the first place, in the first instance. So for all these various interests, the university could simply say that communicating the outcomes of an investigation to complainant is covered by Article 6F of the GDPR, legitimate interest. Once again, in this case, it becomes a question of necessity and proportionality. So who should be made privy of the outcomes of an investigation? Should it be the complainant only? Probably yes. Probably shouldn't be the whole community, except in extremely serious or systemic cases, right? So question of proportionality, gravity of the sanction and the offense versus amount of people who get to know about the sanction imposed. So there is one variable there. Another variable could be how much detail do you add to the complainant, say. So you could say, for example, you can inform the complainant whether the allegations of misconduct were upheld or not. Fine. Whether measures were taken. Fine. Whether the respondent remains in their position, right? Or how the outcome will affect complainant safety. All of that, I think, is fair game. It might become more problematic if you start adding a lot of extra information in the disclosure, right? So, for example, if you share with the complainant the full disciplinary report, if you disclose very detailed reasoning about the respondent, if you disclose other instances of sanctions that the respondent might have, other investigations in the past, for example, maybe that's not necessary. So again, it's a measure of calibrating the disclosure in a way that is necessary and proportionate to the legitimate interest you're pursuing. But in and of itself, I don't think that there's, once again, any preclusion in the GDPR against this type of disclosure. It depends on how you do them. That's why I said there's a lot of balancing value judgments that must be kept in mind. I don't know if I have time to provide you with an example from the case law.
Yes, of course, we have time.
So one case that I always find is not directly relevant to gender-based violence, but it's kind of good in explaining how balancing really works. There was this OT versus VTEK case, difficult title. There was a case about a Swedish politician and civil servant being appointed to a public commission for procurement. And the Swedish law requires that whoever occupies that position must disclose through a website that is accessible to the whole public every business interest that they might have in private companies, but also any business interests that their spouse might have in any private companies. Now, these politicians said, well, I understand the purpose, that is preventing conflicts of interest, but the means put in place are too intrusive. Why? Because, for example, in that case, revealing the identity of the spouse, well, would already be kind of intruding in the spouse's personal data. And also because it turns out that the spouse was a person of the same sex, this politician had run without disclosing the fact of being gay. So that is something that the politician said, maybe this is my private life. So the question for the court was, is this disclosure requirement proportionate and necessary? And the court said, well, not really, and used the heuristic that I told you about a moment ago. It was like, is there an alternative? Can we still reach the goal of preventing conflicts of interest while being a little less intrusive into privacy? And the court said, yes, probably. You could, for example, have this politician and their spouse disclose all of their business interests to a parliamentary commission or another type of commission that would still monitor no conflicts of interest without the need for the whole Swedish population to know about it. So this is the type of reflexes as you design your systems, and also disclosure of outcomes of investigations with complainants or other community members. Keep that in mind, right? Is this the least intrusive alternative option that I have? Maybe it is. Maybe you want to really preserve trust in the system. You want the complainant to be able to appeal, etc., etc. But always ask yourself that question. If you do it right, if you fine-tune the toggles and dial right, then you're off the hook, then you're covered.
Thank you. Thank you for the example and yes, the clarification. I think it really covers one of the main points that come up from every gender-safe discussion. So thank you. I think now we can move on to the Q&A part of our webinar. So once again, to everybody, feel free to leave your comments in the chat if you'd like. And also, if you want to raise your hand and ask your question out loud, we can also do that. Since I have seen some movement in the chat as we have been speaking, and my colleague here, Anna Brandl, has been monitoring the chat, maybe Anna, you could tell us some of the questions that the participants have raised?
Yes, happily, and thanks, Tommaso, for your presentation. The first question that and they are asking particularly about Article 9 of GDPR. So for everybody who doesn't know GDPR by heart, I just copy-pasted there in the chat the link to Article 9. Which is the article that discusses processing of special categories of personal data. And the question is, the question from Sarah is, under what conditions, so the article is basically prohibits the processing of certain kinds of personal data, among them data concerning a natural person's sex life or sexual orientation and health, and so on and so forth. And then the article gives us from A to J reasons to make that processing lawful. And the question is, under what of these conditions, one or more, I assume, on which of these conditions could the university rely on to process the special category data of the respondent, if we agree on the fact that sexual violence report might fall under this special category of data because it includes probably information about someone's sexual orientation, sexual life, etc. So it's specially protected according to my lay understanding of GDPR. So here the question is, okay, then out of all these A to J, what could we use to justify and to legitimate process that data?
Great question. You're right. So many personal data that are relevant for gender-based violence may fall under the category of special personal data, that is particularly sensitive personal data, including data about the sexual life of the data subject, just to mention one, but also many others. So again, my advice is to take a belt and suspenders approach. Always try to have more than one lawful processing ground in place, so that if one fails, the other is still there. In a sense, throw in the kitchen sink. So first, consent. Data subjects can give explicit consent to the processing even of special data for one or more specified purposes. What differentiates explicit consent under Article 9 from simple consent under Article 6 is subject to debate, but in order to be on the safe side, when you prepare your consent forms, make sure that you highlight the fact that as part of the processing of personal data for the purposes of eradicating gender-based violence with these procedures, these mechanisms, so on and so forth, you might also process highly sensitive data, and ask your community members to separately kind of tick that box or sign that clause separately, and so that you can be covered under Article 9A. Then you have several others grounds that are not consensual, even when it comes to special data. I think I would name a few. I would say that processing is okay, even when it comes to special data, if it's necessary for the purposes of carrying out obligations and exercising specific rights of the controller of the subject in the fields of employment, social security, and social protection law. So this is little paragraph B. So there too, a university might have the right or even the obligation to act under the social protection laws of their state, also in the field of employment. So you could have, for example, an employment right in your country that says that part of the employees' rights is to live in a gender-based free environment, to work in a gender-based free environment. That's a potential justification. Social protection. So B is potentially a good ground for processing. Another one could be when that, of course, arises. Hopefully that doesn't arise that often, is processing necessary for the establishment, exercise of defense of legal claims. So Article 9F. So suppose that you're a university that is investigating misconduct, and it turns out that misconduct might actually be actionable in court, either at the criminal or at least at the civil level. So in that capacity, if the universities decide to sue the employee or the staff member or the community member that has committed misconduct, they will be able to use those collected personal data as evidence for the establishment, exercise, or defense of legal claims. And so, and finally, you have G, and that is probably the broadest, but so processing being necessary for reasons of substantial public interest, again, subject to proportionality requirements. So here a good argument could be made that, once again, we're not talking about a low-level interest that we are pursuing here. We are pursuing the goal of ensuring gender-based violence-free environments, and that reflects a substantial public interest. Of course, then the proportionality scrutiny becomes very strict, so you must be able to show that the amount of specially sensitive data that you process is necessary for this type of goal, in pursuit of this type of goal. But then again, I don't think, long story short, that Article 9 necessarily precludes the processing of highly sensitive personal data when it comes to building or rolling out eradication mechanisms. I hope I didn't ramble on for too long on this.
I wouldn't say so. I think it's very clear. Thanks for the answer, Tommaso. I go forward then with our next question, that it's somewhat related to one that Diana posed. Diana's question was specifically about information access requests. This one, not necessarily about that, but similarly. The question is, if a complaint, either anonymous or confidential, is filed against someone, must the alleged harasser or the respondent, let's call them, must the respondent be informed, and when, that a complaint has been submitted and that the university will begin investigating it?
That's an excellent question, and one we've been grappling with also as ombudspersons here at CEU. It's a question that can be answered not so much maybe from the angle of data protection, but rather under the angle of due process, labor law, depending on the country you are based in. You might have, for example, rules that prevent disciplinary actions against an employee without certain procedures, without an independent investigation, due process, the ability to defend themselves, and so on and so forth. So under, for example, this could be a case, I don't know the domestic laws of all of your different jurisdictions, but you could be under that type of obligation. In that case, you must make sure that the reporting and investigation and monitoring systems comply with due process requirements. Here at CEU, for example, the identity of the complainant can be kept confidential from the alleged harasser throughout the proceedings, but no disciplinary investigation can be opened without the investigated person knowing. So the moment our disciplinary committee decides that a case is admissible, that there is enough evidence to open an investigation, the first thing that they must do is to notify the respondent and let them know that there is an investigation against them, inviting them to present their evidence, their position, and so on and so forth. And I think that this is good practice. It might be tuned differently depending on your countries and institutions, but I think that once you have a fact-finding, once you have an investigation that may result in sanction, it's good practice to give alleged harassers an opportunity to defend themselves. If anything, because otherwise you undermine trust in the process and the legitimacy of the process.
Absolutely. So for what you're saying, is not so much a GDPR question, but a question on due process and the right to defense.
If anything, data protection here is important in to preserve the identity of the complainant. So whoever has access to the identity of the complainant must make sure that they do not disseminate that identity. That's a breach of the GDPR.
Understood. What you're saying is, of course, it's good practice to share this information that an investigation has been opened with the respondent, but that doesn't mean that the identity of the person putting forward the report has to be revealed if this person has chosen to keep their identity confidential, then this has to be redacted or should be redacted from the file.
Yes.
Thank
And
you
so
very much.
for witnesses, for whoever has, so the problem again, the respondent should have an opportunity to defend themselves. So you should have witness reports that can be challenged, but some witnesses might request confidentiality of their identities too. So it really depends on how you set up the procedure with due process requirements in mind. There's always, I know it's the lawyer's response, but proportionality balancing is key to these various branches of regulation.
Makes total sense, and looks like it's due process question, and also protection for whomever is putting forward the report, that the confidentiality of their identity is preserved, and how to balance this with due process. Next question, it's about reporting. So, sorry, not reporting, but rather monitoring reports. And it's a question on anonymization techniques,
Yes.
which is a case for small institutions when you're about to basically do your monitoring report on incidents, amount of complaints, and et cetera, et cetera. Of course, anonymization is easier and easier the bigger the data set, but what do we do with small data sets? It's a struggle, says our participant here, to find a way to truly anonymize data when your unit or your university organization has small numbers, especially when it's about, so depending on the granularity of your monitoring report, if you are including gender data for non-binary people, maybe you have one non-binary employee in the entire institution. And of course, the pseudo-anonymization here is not going to work because this person will be easily identifiable. I think this is an issue, at least that I experienced in the university, actually with another topic, a topic of gender pay gap. So how much you can report per category without actually making people identifiable. And we have a rule of thumb of 10 subjects, and until you can actually make a monitoring report on that particular category. But I'm curious to hear your thoughts about which, if there is any rule of thumb on how to go about small numbers when it comes to monitoring reports. Because of course, universities wants to be transparent and show that work is being done, but how can we protect people's identities and
There is a challenge, you're right, and this is a very good question. So the only kind of legal guidance that we have is that an identifiable natural person, I'm reading from Article 4, is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, or line identifier, or one or more factors about physical, physiological, genetic, mental, economic, cultural, social identity. So clearly, when you want to truly anonymize, you need to remove indirect identifiers. I just joked about the male Italian professor at the Department of Legal Studies of CU. So there will be clearly a number of identifiers that would need to be deleted from my file in order to make me not identifiable. But these can be a challenge with small sets. I'm afraid that the only way to truly anonymize small sets is to reduce maybe the utility of reporting and to only provide the information that can be provided. So if you have a very small set of data subjects, you can still get some use from, for example, limiting strictly your reporting to allegations, right? If you're a group of 10 people, small, very small data set, you can still say that over the last year, among this group of 10 people, 4 cases were reported. 2 cases of sexual harassment and 1 case of, I don't know, discrimination, and so on and so forth. And then say something, these cases touched, well, it depends at that point on the composition, but for example, levels of seniority, depending on how the distribution works. So the more granular it become, the closer you get to identifiability. So I'm afraid then we have very small numbers. What you can do is either merge with other data set where useful, right? So to increase the level of aggregation, or to reduce the utility, the use of information by only kind of keeping the information that is truly, truly anonymous. I know it's a challenge and this is not really an answer. There's a lot of best practices out there. One place I would look at is academia itself, not when it comes to gender-based violence, but for example, when it comes to research design. A lot of qualitative scientists in political science, say, who interview people about their political orientation. So political orientation is highly sensitive personal data. You run your interviews with, I don't know, 20 interviewees and try to write an article out of it. Your data protection officer storms into your office and say, okay, now how do we truly anonymize all of this if those people have not given consent? There's a lot of different techniques that are used, but inevitably anonymizing small sets reduces a bit the amount of information that you can actually report on.
Thanks, Tommaso. I think it is very clear and very useful. I pass now on to Diana, who will continue picking up the questions from the chat.
Thank you, Anna, and thank you, Tommaso, for answering very thoroughly all of these questions. I think from the chat we have one more, and again, if anybody wants to raise their hand and ask their question out loud, they can also do that. Our question comes from the context of Austria. So this participant is asking whether an independent body of a university, so there is apparently a working group within the university, can also base their processing of personal data on the duty of care. And here they cite Article 18 of the Austrian Employee Act. So they want to know whether this independent body can process personal data, or if it's just the university itself as I'm guessing, legal entity, an independent one. Any thoughts?
The short answer is I don't know. The short answer is, so the questions of organization of employers under the Austrian Employee Act are not really my domain of expertise. I, however, can answer with let's reason through the answer together, right? So first, if the body, the Equal Opportunity Working Group, was it called, is however independent part of the structure of university, so it's an integral part, is like a branch established under the university, it would make sense to me to hold that body liable and subject to the duty of care, because it's the university as the employer at large that is subject to that duty, right? So if my disciplinary committee here at CEU, which is an independent investigative body for harassment cases, among others, acts in a way that creates a genuine risk to the health and safety of a CEU staff member, I don't think that the disciplinary committee could simply say, sorry, I'm independent from the university in my funding capacity, and therefore I don't have a duty of care vis-a-vis the people I'm investigating. I don't think that that would be the case. So that's the extent of my more common sense answer to this question. I know it falls short of a convincing one, but I can go back and maybe come back with I can send an email to Diana for her then to be in touch. Apologies for not being able to answer more thoroughly.
No, thank you. Thank you for your answer still. So while we wait for a couple of more questions to see if anybody wants to ask anything or share any case studies with them, I think I wanted to raise something that came up in our survey. So when we were organizing this webinar, we sent out a survey to participants asking if there were any particular topics that they wanted for us to discuss. And something that came up, and it's also something that keeps on coming up in our community of practice, is the sharing of information between institutions. So, and I know you mentioned this briefly in one of your slides, because basically a problem that the European research area has been facing is this problem of passing the perpetrator. So we have people with sanctions after receiving a complaint of gender-based violence within an institution, who then move to another institution. And I know this can be employees or also students who then move to another institution, and then this new institution has no information on the history of misconduct that this person may have. And there have been some alternatives or some proposals on how to deal with this problem. In particular, we know of the misconduct disclosure scheme, which has been organized in the context of the humanitarian sector. However, this type of schemes or proposals are based on the idea of one institution sharing basic information, for example, on the history of misconduct, on who this person is, on what findings were upheld, with the new employer, sorry. And so this for us raised a lot of GDPR questions, and we wanted to know, okay, would this be possible? Are there any limitations or constraints? So if you have or could provide basic guidance for us on the topic of sharing information between institutions, that would be great.
Well, yes, fantastic. I knew that these would come up at some point in the discussion. I think that these information sharing mechanisms can be extremely useful, but they must be designed appropriately. Once again, I don't see anything under data protection law that would bar those systems. There will probably be quite a bit of scrutiny in how you design them. And I guess a problem, so take one university, I'm taking my university, CU, as the example. So these information sharing system will work both ways. CU hires somebody new, and they request information about that somebody from their university of origin. So this is one scenario. And under that scenario, well, you can have so many different permutations. So you're hiring, say, a US professor, or coming from a US university, well, you're in luck because the US doesn't have these type of data protection obligations by and large. So US universities might be more willing to send you relevant information about your new hire, right? So if it comes from non-GDPR jurisdictions. If it comes from Europe, well, by asking that information, you might have to justify your processing, right? Quite carefully. So first, I would say, once again, consent. You could ask candidates in the recruitment process whether they agree for you, for your university, for CU here, to acquire information about potential sexual misconduct from their former employers. So you could try and secure consent for that specific purpose. Again, with all the transparency obligations, telling them how these information might be used, etc., who would have access to it, and so on and so forth. You could, again, refer to your legal obligation or official authority to secure a gender-based violence-free environment. So in pursuit of this goal, we are processing sensitive information of our new incoming employees by asking their previous employers. Or you could also refer to legitimate interest. Again, very important, necessity and proportionality. What are you asking for? Are you asking for example, only outcomes of investigations? So can you ask, have you been investigated? Yes or no? And if so, what was the outcome of that investigation? That is one thing. It's another thing to say, now give me all the reports, all the deliberations, all the witness statements that were filed during those investigations. That might be disproportionate and unnecessary vis-a-vis the goal that you are trying to achieve here. And this is for the intake of communication from the other employer. Go the other way around. So a CU professor applies to another university in the GDPR zone. That university requests you to disclose information. Can CU do that? Once again, yes, under certain conditions. Is the person consenting? Great, you're off the hook. Is there a legal obligation of duty of care? Well, this might be a little trickier because CU must care for its own employees. Should it also care for the employees of another university, prospectively, right? Maybe or maybe not, depending on how you interpret the duty of care. There will be better experts than me in the room on these issues, right? Legitimate interest, same. So I think that the legitimate interest here would be a fairly solid ground. So you could say the legitimate interest can be interpreted so broadly that it doesn't only refer to CU's own legitimate interest, but also to the academic sector, the academic space at large. So CU is part of an academic environment and gives it a legitimate interest in sharing information that might enable other academic institutions in eradicating gender-based violence. But it's tricky. So that's, again, how you frame it, how you design it. Minimization, data minimization, and necessity and proportionality are always a good rule of thumb to keep in mind. Do not disclose too much.
Thank you. We know it's a tricky topic, and yes, but if people bring it up constantly, and we felt that this was also the space to bring it up. I think people can still post questions in the chat, or feel free to also raise your hand. But in case there are no more questions, I think I would ask the last one so we can let you go and finish on time. I know this has been a very intense session with a lot of information. So if anybody wants to post anything else.
Nothing in the chat, Diana. You can go ahead.
Okay. Okay, I'm happy because there's so much information that I want to ask. But I think my last question will be related to multiple reporting. So we have had a lot of situations where institutions gather reports, so multiple reports against the same person. And whether these can be informal reports or anonymous, but specifically in the area of formal reporting. And people that are involved in handling the reports are asking, is there a possibility of gathering all of these? So for example, when a situation of multiple perpetration is involved, could we gather all of these and treat this case, for example, from an investigation perspective, all the means that we employ, could we take it as one big case against the same person? And so again, this is not only the capacity of the institution to investigate, but also all of these multiple victim survivors that want to report the same person. Here, their rights are also involved. And so our question would be, could this be possible, or are there any constraints or obstacles from a GDPR perspective? And if you have any other thoughts or guidance for institutions.
This is an important question indeed. So when you try to eradicate gender-based violence, you try to go after the big fish too, and it's not so serial perpetrators, systemic perpetrators. And so if you only collect one case here and one case there and treat them separately, you might not necessarily get the full picture. Whereas if you put those cases together, you might have a much better picture. And also, an investigating body might actually get to appreciate the gravity of certain acts. As we know from harassment and gender-based violence, some acts taken in isolation might not amount to too much, but when considered in their persistence and patterned activity, they can really pile up into a very, very serious misconduct. The problem is there under data protection is that if you kind of put these separate complaints into one big box and disclose everything to everybody involved, well, there's a lot of confidential information that gets cross-shared. Suppose in the extreme case that you have a serial rapist, right, that is accused of rape by one survivor, and then separately accused by another survivor. By mixing all these data and making them available to all the parties and to the investigative body, well, you would turn in the situation where one survivor knows about the other survivor's experience, and that might not something that the other survivor wants, either party wants. So I guess that in those cases, the rule of thumb is first try and secure consent. So the cases where I've acted, fortunately not on rape, but on lesser cases where there were multiple reports against the same person, was to go back, and I became aware there was multiple reports, to go back to individual complainants saying, do you agree for me to share these information with either complainants that might have had similar experiences with this perpetrator? To ask them to everyone, and if everyone agrees at that point, you can merge. But if there is disagreement, well then no, I don't think it's a good idea to go and kind of mix everything in. This is also for investigative bodies and disciplinary bodies. I was in a case where a disciplinary committee made a bit of a blunder because there were two complainants on separate cases, and they basically held a joint kind of virtual hearing in the case. So a lot of, hey, oh, you too, I didn't know. So you want to avoid that type of situations unless you have secured explicit consent from all the parties involved.
Thank you. That was perfectly clear. So once again, if there are no more questions, I think we can wrap it up. People are already starting to leave. I think on behalf of everyone here and the Gender Safe Partners, I just want to thank you all for taking the time to join us today, especially you, Tommaso, for your thoughtful presentation. Thank you to all the participants for your engagement. We hope the insights that we've shared today have helped you strengthen your approach to safeguarding information and responding to gender-based violence. If you have any follow-up questions or would like to continue discussing in any way, I've left my email in the chat. Feel free to reach out to me or to any of the contact emails on the Gender Safe website. And we look forward to seeing you at our next Gender Safe webinar. Thank you so much, everyone.